Good morning, everybody, and thank you for inviting me here to speak to you today on the cheerful subject of the potential business impact on companies of a major accident. I do so with some trepidation because I am a lawyer, and often the lawyer is the last person that you want to see. It means that something has gone very wrong, and in Phil's case, it means something else, I think. So it's a particular pleasure to be here to support step change and safety, and Steve Ray in particular. The step change vision to make the UKCS the safest oil and gas production province in the world, and to maintain that accolade is both extremely worthy, I think achievable, but also very challenging, as we have heard from Chris today. It was disappointing, for example, for me to be speaking to a witness the other day, and I was saying, well, surely the worksite was checked before the permit was suspended, to be told, yes, well, we are supposed to check the worksite, but it's not always done. And that sent me into shivers because it reminded me so much of Piper Alpha. I see my role today as one of shaking things up a bit, instilling some shock and awe, and to jolt you from your comfort zone and into a place where you never want to be in the middle of an unfolding major accident, with you leading the response. Is your business ready to withstand the human, reputational, and financial impacts that will occur? Safety is a subject that is very close to my heart. I'm married to a safety expert and specialist, but also I'm passionate about safety because of my experiences and my first-hand knowledge of what can occur when things do go drastically wrong. I want to talk a bit about some of the accidents that I've known and loved, but before I do that, a little bit of law. I promise not to do much law, but I think just as a reminder of what a major accident is, we now have a definition of a major accident. The first involvement I had with a major accident was years ago with the Alexander Keiland, which was a semi-submersible drilling unit, which I think then became a flotel. And you can see there what went wrong with it, but the main thing is that 123 workers died as a result of that incident. And then the next one I was involved with was Ocean Odyssey, which again was a semi-submersible drilling rig operated by Odyssey, and one person died, and unfortunately that person had actually gone back in to the semi-submersible to try to recover some documentation. The next one is Piper Alpha, and I feel very humbled to be talking about Piper Alpha with Steve being present in the audience. I think everybody knows a lot about Piper Alpha, but there were three partners, Texaco, Thompson, and United Texas Petroleum, and there were 226 personnel offshore. Only 37 were Occidental staff, and the rest were 189 contracting parties. I'm not sure what the balance is nowadays. I would think there's probably more contractors present than the oil company. And it did hold the record for producing 360,000 barrels of oil a day. I'll come back to Piper. That is the Tarleton riser explosion 20 minutes after the first explosion, and that was the very thing that Lord Cullen was talking about in the clip that we heard from Steve this morning, and that was what was predicted would happen, and indeed it did happen, and that was a game changer in relation to getting people off the platform. And that was how it ended up the next morning. And then the next one is P-36, which was off Brazil, a floating production platform. That's what happened. And 11 people died and 61 were evacuated. The next one is Bombay High. Now, Bombay High, Mr. Chowdhury was a third chef on the MSV Samudra Suraksha. And he, unfortunately, when there was a storm, put his fingers into a spice grinder. And there was no medic on board the MSV, so he had to be taken to the Bombay High platform for medical attention. But the MSV, when it was approaching the platform, collided with some new platform risers and caused the explosion. And there were 384 persons on board, 22 died, and 362 survived. And then Bourbon Dolphin, this is the last lot. This was a very sad incident. It involved a Norwegian anchor handling vessel and with a Norwegian crew. It was a very new vessel. I think it had only been in existence for 6 months. The accident happened and she capsized as a result of inadequate stability, it was decided. Well, the sad thing was that 8 people lost their lives, including the master's 15-year-old son, who was on secondment work experience. So these are the things that can happen. If you had been asked the question on the 19th of April that whether a major loss offshore could bankrupt a large international oil company, what would your reaction have been? And that's almost what happened on the 20th of April with Macondo. And these are slides of what it looked like and the impact it had. So I think in this talk I want to divide the impact on the business between the immediate aftermath and how you as leaders would have to deal with that, the reputational impact and the financial impact. So if we look at the immediate impact, that's on the human reaction and to the disaster, and also the huge impact that it has, immediate impact on staffing resources. So this was the status of the platform when I arrived at Occidental the next day, the next morning. I went into the Occidental's office at Bridge of Don, and in fact it took over 3 weeks for these fires to be extinguished and well secured. There were 226 people on board, 61 survived and 165 died. 109 died of smoke inhalation, 13 by drowning, 11 as a result of injuries including burns, and 4 cases where the cause could not be determined. 30 bodies were not recovered. I recollect that when I arrived at the building, there was an overwhelming number of press and TV present, and they were thirsty for news, and these numbers grew considerably over the coming days and weeks. When I did eventually get through to the office, the first thing I realized was that Occidental's personnel were in a deep state of shock and disbelief. Many were grieving at the loss and of friends and indeed some relatives with whom they had worked for many years. It was a scene of utter chaos. There was an element of sackcloth and ashes, but there was a huge uncertainty and potential for poor decision-making, and people were really very tired by that time. Nowadays, of course, you all undertake emergency response training and exercises, but I say that nothing will actually prepare you for this wave of despair, and you, as leaders, will have to take control of that situation. There are many avenues that you have to cover, and starting with the ongoing offshore and emergency response, assessing the stability of Piper Alpha, for example, surveying subsea and the plans for controlling the wells, involving Red Adair, who came across to assist. And Piper Alpha was destroyed. Claymore, Tartan, and Flotter were all shut down, and that represented 10% of the North Sea oil and gas production, and it was unavailable at that point. The main issues, I think, for you will be to manage the press as a starter. The media demands were immediate, they were incessant, they were insatiable, and handling the press calls and next of kin inquiries and the press releases was really quite a struggle. And of course, this was long before the internet and the social media, the trolls, the 24-hour news channels, and the current trend for intense public scrutiny and demands for immediate justice. Grenfell is a good example of how things can go terribly wrong. And you have to expect terrible photographs being sent from the platform as people try to escape and from the rescue vessels. Goodness knows what kind of social media frenzy will be instilled. Then you have to speak to the next of kin. I recall that there were real problems with that in relation to Piper because the persons on board list was not up to date for some reason or other. And I remember that one wife thought that her husband was on board only to find that he was not and that he was with another woman. You also have to manage the parent company and the co-venturers. As you saw, Oxy had 3 partners, and we had to review the joint operating agreement and see that, for example, if Oxy was guilty of willful misconduct or sole negligence, then they would not have to pay up. The insurers were also involved. It wasn't like BP, because BP was self-insured. Occidental was insured. I haven't got time to go through that insurance with you, but suffice it to say that it was extremely complicated and there were gaps in the cover, much to everybody's concern. You also have to deal with the police because they have primacy. They want to investigate and they'll be making demands for documents and eyewitnesses. You have to deal with the contractors who have personnel on board and source the contracts and look at them and see where they are in relation to liability and have discussions with them. And then, of course, there's the internal investigations. They have to be kicked off, and you have to take out specialist resources from mainstream operations to gather documents and deal with that sort of thing. Then there are the environmental issues. With Piper, there were no environmental issues. There was no pollution. One of the big things that I had to deal with was the fact that there were ambulance chasers who were coming across from Europe, from USA. The next day, a guy called Bentham Musselwhite came across to try to speak to the next of kin and get them all to come together in order to raise proceedings in the USA. So it was important for us to make sure that that didn't happen, and so we handled the claims, and in fact, they were settled in relation to the fatalities within 100 days from the incident. And that was with the assistance of Lloyd's insurers. And in addition to that, we had meetings with co-venturers, insurers, lawyers, sometimes 60 to 70 in a room, and that would certainly be an anathema to fill. And then, of course, the public inquiry happened 1 week after the disaster. It was Lord Cullen was appointed, and there were great demands for documents. In fact, the Crown asked, I think they produced a huge bundle of 5 lever arch files just with lists of documents that they wanted. So if you think about your own document and data library, how many documents is that going to involve, and how many people are you going to have to resource to fill that issue? With Macondo, for example, BP say that they mobilized approximately 48,000 people, the coordination of approximately 6,500 vessels, the deployment of approximately 2,500 boom, and they devoted the personnel devoted some 70 million personnel hours in response, which is quite a thought. So let's see what happens with the reputation, the business reputation. It's difficult to see how a Piper Alpha or a Macondo could happen without some impact on reputation. And in fact, Piper Alpha resulted in Occidental changing its name and then eventually quitting the North Sea. After Macondo, BP's reputation was in tatters. As a result of Macondo, deep water exploration in the Gulf of Mexico came to a virtual standstill for about 9 months. And then in 2012, the US Environmental Protection Agency imposed a Macondo-related ban on the award of federal contracts to BP, including Gulf leases. This ban was lifted just shortly after they had come to a settlement agreement with regard to the pollution costs in 2014. And now what we have is BP firing ahead, and they have weathered the storm. They are the top oil producer in the Gulf. And so they have made it through. But could every oil company make it through in that way? Another important thing in relation to reputational damage is handling the press and proper press communications in the initial stages. I think EPOL's protocol for media relations, which was issued in June 2013, is very useful in that regard. And it says that in a major offshore incident, the importance of holding a multi-agency media conference at the earliest opportunity cannot be overstated. I would go further than that and say that you should take control of the press coverage, and that in the event of a major accident, the company should hold an initial early conference. As we've seen and heard from Phil, often the external lawyers intervene and say, no, don't do that, and advise against a press conference, or issue an anodyne statement, or worse still, they make no comment at all. It's all a question of building trust. But you can't stay in your ivory tower whilst the mob outside wants to know what's happening. It's important for you to display public regret for what has occurred, and that must be done out of all humanity, and it must be the way forward. That can be done without any admission of liability, which is what I would want, but with a genuine desire and commitment to carry out a thorough investigation into the cause. For example, in Piper Alpha, Armand Hammer was the face of Oxy Management and came across to Aberdeen, and everybody thought that that was a really good thing. But in point of fact, he had to be persuaded to come. In Grenfell, we had the borough just making a complete botch of it and pretending it wasn't happening at all. And then in Macondo, at the initial stages, if you all remember, Tony Hayward did not make a very good job of it. He used words like, or phrases like, I'd like my life back. And then he went shortly afterwards to Cowes to watch one of his boats in a race. And that provoked President Obama's chief of staff to say that this was yet another gaffe in a long line of PR gaffes. And as a result of that, of course, Hayward was replaced by Bob Dudley. But BP understood that the PR campaign had been lost, and I understand that they launched a $90 million PR campaign to restore the trust, which seems to have been effective. In contrast, Total, after the leak in the Elgin Franklin field in 2012, took control. And I understand from a paper that they presented to Piper 25 that they developed an early communication to be open and transparent, both externally and internally, and they appear to have done a really good job. And then another way to keep the reputation under control is the way you handle the claims at the outset. Now, this can be really daunting because there are so many of them around. But in Piper Alpha, we established very quickly, within a matter of days, a communication for negotiating claims, and with the full cooperation of Lloyd's. And we were able to, as I say, resolve these death claims very quickly, and we set up a verification process so that I, in fact, negotiated the claims and then went down to the insurance verification committee, and they rubber-stamped the claims, and then the payments were made. And all of the death claims, all payments were made within a year of the anniversary. Macondo, Obama announced that the BP had agreed to pay $20 billion to a fund for claims and cleanup, and that Ken Feinberg was appointed to administer the fund. We look at financial cost. What are the financial implications? With Piper, the result was, of course, a loss of $1.25 billion. P36 was about $500 million. With BP, let me just BP. We're told that the loss was nearly 65 billion, but I've been looking at a study that was produced in 2018, which puts the loss more at 145 billion. I've got a copy of that study if you would like to see it. And the additions that the analysis had put in was, for example, 680 million for legal fees. Now, some might think that that's excessive, but I couldn't really comment on that. It also includes a figure towards the hidden costs of reputational damage and loss of profits. Now, BP did get some money back. They were self-insured through their captive Jupiter. They got money back from the partners, 1.7 billion from Mitsubishi, and about 4 billion, I think it was, from Anadarko. Weatherford contributed, as did Cameron, but there was no contribution at all from Transocean or Halliburton, although BP was an additional assured on the Transocean pollution insurance policy. There were multiple investigations, multiple and civil and criminal suits from the Department of Justice under the Clean Water Act. Now, what impact did the loss have on BP's market value? Apparently, they lost half of the market capitalization. The stock value had been $187 billion a day before the oil spill, and a third of that was lost in a few months. Once again, an analyst has come up with a loss in the market capitalization of 61 billion after the spill, and up to a range of 83 billion at the worst time of the crisis. So that gives a summary of where we are with potential financial costs. There were criminal suits and civil suits raised, and it was interesting because the Department of Energy wanted the stiffest of fines and sought to prove that BP was grossly negligent and engaged in willful misconduct. And BP said it was just a tragic accident. There was a ruling of gross negligence, which would have, it would have resulted in a fourfold increase in the Clean Water Act civil penalties. Yeah, as regards to the criminal offences, then in fact BP did plead guilty, and they agreed to pay 4.5 billion in fines, 4 billion for criminal charges, and 525 million to the security regulators for deliberately underestimating the amount of crude released. They were described as reckless and wanton. And in fact, 4 employees were also charged, 2 with 22 counts of manslaughter, and they were facing a lifetime in prison, and 2 with obstruction of justice, and that was a 5-year imprisonment. Finally, all the manslaughter charges were dropped, and 2 were acquitted after trial, and 2 pled guilty to a very minor misdemeanor, one of whom got 10 months probation, and sadly that chap died about 2 years later. And as regards the civil suits, a settlement wasn't reached, and so they had to go to trial. And the first part of that trial was to find out whether, in fact, they were guilty of, whether BP was guilty of gross negligence and willful misconduct. And in fact, Barbier decided that they were. That they had spilt 3.19 million of barrels of oil, and that they had been reckless in the way that they had performed, and they had been acting with conscious disregard of known risks, and its employees took risks that led to this huge disaster, and the decisions were primarily driven by the desire to save time and money rather than ensuring the well was secure. So they reached an agreement to pay $2.8 billion for $8.1 billion for natural resources, and $5.5 billion for clean water civil penalties. Could such an enormous loss arise, a financial, human, reputational loss arise in the UK in the event of a major accident? Well, there would certainly be a public inquiry, but not the endless investigations of Macondo. There would be a multitude of personal injury and death claims. I don't know the extent of the potential threat of US litigation because the UKCS has seen many new entrants who are not really connected with the USA, so US jurisdiction may be more difficult to establish. Cleanup costs, anyone's guess, and there certainly would be a multiple number of actions involving partners, insurers, and the like. But the big thing will be prosecutions. In Piper, there were no prosecutions, and that was because the rest of the industry seemed to be found to be in the same state as Occidental, and also the ineffective regulatory body, the Department of Energy, hence why we now have HSE. So what would happen in Scotland if there was a prosecution? Well, it would be down to the Crown Office and the Procurator Fiscal to prosecute the company, first of all, and the company would be prosecuted under the corporate manslaughter legislation of 2007, which applies to the whole of the United Kingdom, known in Scotland as corporate homicide. And they would also include breaches of health and safety at work, section 2 and 3. And in England, the same would happen. And just to remind you, and I won't go through that, what corporate manslaughter actually is. And it applies only to the company. However, individual employees, like the leaders, the senior management team, the people in charge, can be charged with, in England, common law gross negligence manslaughter, and in Scotland, culpable homicide. And they can also be charged with breaches of the Health and Safety at Work Act. Since the introduction of the Corporate Manslaughter Act, only 26 convictions have taken place in England and none at all in Scotland. So why is that? And it's because of the difficulty that the prosecution faced. They must prove that the defendant company's gross breach of duty that led to the death was substantially due to the way in which activities were managed or organized by its senior management. The requirement to demonstrate causative senior management failure has meant that most of these convictions have been with small firms with much easier ability to prove that the management caused the issue. In a substantial number of cases where there's a corporate manslaughter charge and a conviction, there has also been company convictions under the Health and Safety at Work Act, and also convictions of individual directors and employees for gross negligence, manslaughter, and breaches of the Health and Safety Act. Since the 1st of February 2016, the custodial sentences have ranged from 10 months to 10 years. Looking very briefly at the sentencing guidelines, because I'm sure you've all familiar with this, but in England, these guidelines were brought in for health and safety and corporate manslaughter in 2015. The Scottish Council, Sentencing Council, is lagging a bit behind. They have brought in some very general guidelines and promised to introduce some more offence-specific guidelines, but that is going to take some time. So the question is, what will apply in Scotland? Will the English guidelines be looked at by the judges who are dealing with these cases? Now, English guidelines are not legally binding on Scottish judges, but they have been considered in the Scottish courts since their introduction, and their use as a cross-check for the levels of fines has been approved by the appeal court. So we can't escape simply because we're north of the border. And also, that makes sense because the Health and Safety at Work Act and the Corporate Manslaughter Act are UK-wide legislation. So we need to understand the 2015 guidelines. And they have provided separate guidance for levels of corporate manslaughter and HS for companies and HS for individuals. The court, in order to reach a fine, requires to work through a number of steps. And the first step is to decide on the overall seriousness of the offence based on the degree of culpability, which ranges from low to very high. And very high is a deliberate breach or a flagrant disregard for the law. And then they look at the level of harm caused and risked. the likelihood of that harm ranging from 1 to 4, so low, medium to high. High is death, of course, death or serious injury. So there's the culpability guideline and the harm. And then they have to then assess, after seeing what the overall seriousness is, they must consider the financial position of the organization, having regard to turnover. They identify the appropriate range of fines for a series of published tables, and that gives the tariffs. So we've got from micro-organization to large organization, which is 50 million plus, to very large, which is sky is the limit because there is no limit, and it's for the judge to decide what a very large company should actually have to pay. The fines are supposed to be sufficiently substantial to have a real economic impact, which will bring home to management and shareholders the need to comply with health and safety regulations. It's just a slide showing the tariff for a large company for health and safety offences, which you'll see is a starting point of 4 million and goes up to 10 million. And the next one is for corporate manslaughter, which has, for large companies, has a starting point of 7.5 million and goes up to 20 million. This is an important slide because it mentions the fact that for a very large company, where the turnover very greatly exceeds 50 million, it may be necessary to move outside the suggested range to achieve a proportionate sentence. So there's no starting point and no final end figure. But it clearly says that fines in excess of 100 million will be on the cards for Piper Alpha Macondo type incidents. And these are not insurable and they're not tax deductible. So I have listed there some of the most recent fines involving very large companies, just so that you can see the way it's heading, and it's certainly heading upwards. And then the next thing is the gross negligence manslaughter, which is the one where the individual, the director, was imprisoned for 10 years, and that involved SP fireworks, and there were 2 deaths and 4 injuries. And the judge said that the company, and the man in particular, showed an arrogant recklessness for safety of others. Now, on the environmental damage side, we have here the biggest fine ever, and that's a £20 million fine for pumping 1.9 litres of untreated water into the Thames by Thames Water. And they had a $2 billion or £2 billion turnover. And then, a year later, they were also fined, but they were only fined £2 million that time because they'd actually pumped £40 million into some research and improving their work sites. So 20 million is the highest. In fact, the highest health and safety fine still stands at 15 million for the death of 4 people in a gas explosion a long time ago. So if we go back to that quote from the Thames Water case, there is mention there, as the appeal court says, of levels of fines of 100 million and more, and that is now being seen in the financial services market, and that's absolutely true. And there's little reason why they would not be acceptable and reasonable for criminal offences committed contrary to the health and safety and environmental regulations, for that just to follow the FCA route. And I haven't got the slide here, but in fact, during the calendar year ending 2019, the Financial Conduct Authority actually fined or imposed fines up to £350 million. That included Tesco, who were fined £129 million for overstating profits, and Standard Chartered of £102 million for money laundering breaches. So I think that's the way that we're going, and I think that is certainly what we would see in the event of a major accident. So the impact of a major accident on a business is could be catastrophic. And if it can be said that there are serious failures within your company and that has led to a disaster, then you're putting lives of the workers at risk, the very survival of the company, but also your own liberty. If the dice is stacked against you, and a near miss can so readily become a disaster. So to quote Brian Appleton, who was an assessor at Piper Alpha, safety is not an intellectual exercise to keep us in work. It is a matter of life and death. It is the sum of our contributions to safety management that determines whether the people we work with live or die. Thank you.